So I'll be starting with the first issue, is whether Tan Sri Baru's removal from the cabinet and his party after criticising the Prime Minister has violated his right of freedom of speech under Article Clause 1A and his right of being heard under Article 5 Clause 1. So discussing the rules for this issue, Article 10 Clause 1A of the Federal Constitution has guarantees the Malaysian citizens the right to freedom of speech and also expression. So this constitutional right is exclusive only for the citizens. Non-citizens, they may express their opinions. However, Parliament, they may impose restrictions as deemed as necessary. So what is the scope of expression? So freedom of speech includes more than just words. It covers the symbolic forms of expression such as the painting, photograph and also illustrations. So by looking at the case of Mat Suhaimi binti Syafiee against Pendakwa Raya 2014, freedom of speech is not absolute, especially in common law countries. It is subject only to reasonable legal restrictions. So, under Article 74, Parliament may enact, amend or repeal law that limit this freedom, but this law must be justified as necessary or expedient only in the public interest. Next article that is relevant to this discussion is the Article 10 Clause 2A that allow the Parliament to enact the law that limits the freedom of speech. So, these restrictions are valid only if it is made in the interest of the society, especially to maintain the public order and also to uphold the morality. So, these limitations are legally and constitutionally valid even though they restrict a fundamental right. So, Article 63 Clause 2 that discusses about parliamentary privilege, which is the protection for the members of the parliaments, where it grants the members of the parliament an immunity from legal proceeding for statements that is made only in the parliament. So, what is the purpose of this Article 63 Clause 2? It is to ensure these members of the parliament, they can perform their roles without any fear of external interference. And then the limitation is discussed under Article 63 Clause 4, where it is no immunity for sedition. So Article 63 Clause 4, it removes this protection for offences under the Sedition Act. So as explained in the case of Mark Coding against public prosecutor in the year of 1983, members of the parliament was prosecuted for seditious speech that is made in the parliament. So the court in that case held that the parliamentary privilege, it does not apply to any sedition offences. So this means that the members of the parliament, they can be charged for seditious remarks even if it is made during the parliamentary debates.
Article 5 Clause 1 provides that no person shall be deprived of his life or personal liberty save in accordance with law. So in the case of Tan Teck Seng versus Suruhanjaya Perkhidmatan Pendidikan and another, the federal court should not interpret only to cover physical life or freedom from unlawful detention, and the court held that the right to life does not only refer to mere existence, but it also includes all that forms the quality of life, which includes the right to work, the right to live with dignity, and the right to be treated fairly. And it is also emphasized that any public servant has the constitutional right to procedural fairness, meaning they must not be removed without justification. They are entitled to inform of allegations made against them, and they are also must be given a chance to defend themselves. So in the case of Lembaga Tata Tertib Perkhidmatan Awam, Hospital Besar Pulau Pinang versus Atrabadi, so the court ruled that the right to life also includes the right to continue in public service, and any form of dismissal must be done fairly. So the court also emphasized that the dismissal from public service must adhere to fair procedures. The public servants cannot be removed without being informed, and they must be given the opportunity or the chance to defend themselves. So Article 5 Clause 1 of the Federal Constitution further explains the phrase safe in accordance with law. It does not only refer to any law, but law that complies with the principles of natural justice. Okay, so in the case of Ong Ah Chuan versus public prosecutor, the court held that law here refers to a system of law that includes the essential rules of the natural justice. So in the case of Datuk Seri Anwar Ibrahim versus Government of Malaysia and another, which highlighted the principles of natural justice, it consists of two. First, rules against bias, which means the decision must be free from personal or political interest. Second, a right to be heard, which means everyone must be given the opportunity or the chance to be heard before any decision affecting their right is made. And so the next case is Kitty Swaran, anak lelaki Kanagara Ratnam and another versus public prosecutor. The court confirmed that the rules of natural justice also includes the right to fair trial, which are the essential parts of Article 5, subsection Clause 1 and Article 8.
Now, by applying the rules to the scenario, we can say that as a Malaysian citizen and a members of the parliament, Tan Sri Baru is entitled to freedom of speech under Article 10 Clause 1A of the Federal Constitution. It includes the ability to criticise the government leaders, including the Prime Minister. However, this freedom is not totally absolute. So by referring to the case of Mat Suhaimi bin Syafiee against Pendakwa Raya 2014, the court recognised that Parliament can limit the speech through law in the interest of the public order or for the morality. So to apply, Tan Sri Baru criticised the Prime Minister because of the failure to address the corruption in the political party. So the remarks were made outside of the parliament. So by applying Article 63 Clause 2, parliamentary privilege only protect the members of the parliament only for the statement that is made in the parliament. So since his comments were made outside, Tan Sri Baru is not protected by the provision. As a result, any political action such as removal from the cabinet or expulsion from his party are not violations of the Article 63 Clause 2 because the speech was not protected under parliamentary privilege. by applying in the case of not coding against the public prosecutor, the members of the parliament made the seditious speech in the parliament. But although Article 63 Clause 2 grants the privilege, Article 63 Clause 4 makes the exception for the seditious act offences. So legal charges were allowed despite the speech being made in the parliament. So in the scenario, Tan Sri Baru case is different. Why? Because he was not prosecuted, but he was faced political backlash. So his freedom of speech was exercised, but no legal immunity applies for the comment that is made outside of the parliament. So therefore, the action that is taken against him do not breach any constitutional protections.
Okay, to apply, Tan Sri Baru was removed from the cabinet after he criticised the Prime Minister, who is also the president of the party. In this case, it was clear that he was not given a chance to explain or to defend himself before he was being removed, and the dismissal was made by someone who is personally involved in this situation, which is the Prime Minister, which creates a conflict of interest and violates the rules against bias. So you can see that Tan Sri Baru was removed without the opportunity to be heard, which violates the principle of the right to be heard. And the federal court in the case of Kitiswaran versus public prosecutor confirmed that fairness and the right to a fair trial are part of the constitutional right that has been laid down under Article 5 Clause 1 and Article 8. So therefore, it can be concluded that Tan Sri Baru, he was removed, his removal was unfair, was biased and did not follow the proper procedure.
So, in conclusion, the removal of Tan Sri Baru from the cabinet and his political party raises serious constitutional concern under both articles, which is Article 10 Clause 1A and also Article 5 Clause 1 of the Federal Constitution. So, although freedom of speech is not absolute, Tan Sri Baru's criticism of the Prime Minister on corruption falls well within the scope of protected expression. So, since his remarks were made outside the Parliament, did not amount to any criminal offence or threat to public order, taking punitive political action against him without following due process is highly questionable. So, it's very important that his removal, without being given a fair chance to defend himself, is actually goes against the principle of Article 5 Clause 1. So Malaysian courts have interpreted this provision to include not just the protection from unlawful detention, but also the right to work, the right to dignity, and most importantly, the right to be treated fairly. So the lack of a fair hearing coupled with political bias, given that the Prime Minister was the one who criticised, clearly violate the principle of natural justice as established in the key cases like Tan Teck Seng, Ultra Badi, Anwar Ibrahim, and also Katiswaran. So we can say that it is evident that the action that is taken against Tan Sri Baru were unconstitutional, as they both infringe his right to freedom of speech under Article 10 Clause 1A and also his right to be heard and treated fairly under Article 5 Clause 1 of the Federal Constitution. Next issue, which is the second issue, whether the Speaker's decision to declare Tan Sri Baru and Datuk Seri Buruk seat vacant under Article 49 Clause 1, 49A Clause 1 is valid, given that they were expelled from their parties, they did not leave or switch parties on their own. Article 10 Clause 1C of the Federal Constitution stated that subject to clauses 2, 3 and 4, all citizens have the right to form associations. So what does it include? It includes the right to form association or union, to join or not join any association, and to resign for them. So no law or authority can unjustifiably interfere with the person's voluntary affiliation with any organisation, particularly with the political parties. So for a case that to illustrate this rule is Dewan Undangan Negeri Kelantan and another against Nurdin bin Salih and another in the year of 1992. So Nurdin, he was elected as a state assemblyman under one political party, and then he joined another political party after being elected. So the Kelantan State Legislative Assembly passed a law stating that any assemblyman who changes party after he was being elected would automatically lose his seat. So based on the new law, Nurdin's seat was declared vacant and a by-election was held to replace him. So in this case also, the court held that such law was unconstitutional because it infringed Article 10 Clause 1C of the Federal Constitution. So the principle that is established from this case is that freedom of association under Article 10 Clause 1C includes the freedom to change political party, but doing so should not cause an elected representative to lose their seat. Article 49A, which is anti-party hopping law, what is the shift in the constitutional position? The constitutional position changed with the introduction of Article 49A of the FC. It provides the legal grounds to vacate the seat of the member of the parliament who defect from the party they were elected under. So the provisions under Article 49A1, a member of the parliament will cease to be a member of the house under three reasons. First, if they resign from their political party, or they are no longer a member of the party, or an independent members of the parliament joins the political party. However, the exception is explained in Article 49 Clause A2, 49A2. A seat will not be vacated if, under three reasons, the members of the parliament party is dissolved, the members of the parliament resign to become a speaker, or the members of the parliament is expelled from the party. So now, the next case to be discussed is the case of Afif bin Bahardin against Dewan Undangan Negeri Pulau Pinang and another in the year of 2023. So what happened in this case is that Afif, a state assemblyman, was expelled from his political party. A motion was filed under Article 14A of the Penang State Constitution, which is the anti-hopping law, to declare his seat vacant. Afif challenged the motion, argued that it violated his right to freedom of association under Article 10 Clause 1C of the FC. So what does the federal court's ruling was? The court ruled in Afif's favour. It held that anti-hopping law only apply to voluntary and deliberate party switching. Since Afif was expelled, he did not voluntarily resign or join another party. Therefore, the motion to vacate his seat was invalid. So the principle that is established from this case is that expulsion is not defection under the law. Article 49A must be applied strictly to voluntary political movements. By applying the case to this scenario, we can see that the Speaker's decision to declare Tan Sri Baru and Datuk Seri Buruk seats vacant under Article 49A Clause 1 of the Federal Constitution. So both MP were expelled from their political parties, not voluntarily resigned or switch party. So Article 49A Clause 1, a member's seat becomes vacant if they resign from their political party, or they cease to be a member, or they actually join another party after being elected. While Article 49A to C, which is the important exception, where it's stated that an MP shall not lose their seat if their membership is terminated due to expulsion by their political party. By applying those cases and the articles, we can say that both Tan Sri Baru and Datuk Seri Buruk were expelled from their political party. So therefore, their termination of membership was not voluntary. So this distinction was emphasized in the case of Afif bin Baharudin, where the Federal Court emphasized that anti-hopping law only applies to voluntary party switching, not to situations that involve expulsion. The court also emphasized that expulsion does not trigger a seat vacancy under anti-hopping provisions. Article 49A to C clearly protects the MPs from losing their seats if they are expelled from a party. It distinguishes between the voluntary defection and involuntary termination. So the Speaker's decision to declare their seat vacant appears inconsistent with Article 49A to C. Since the MP did not leave voluntarily, the vacancy declaration is constitutionally questionable and it's most likely to be invalid. Anti-hopping law aims to prevent betrayal of voter mandate, not to punish expulsion. All in all, we can see that the Speaker's decision to declare Tan Sri Baru and Datuk Seri Buruk seats vacant due to their expulsion from their political party is not supported in the Article 49A2C of the Federal Constitution. Since both members were expelled involuntarily, they did not voluntarily resign or switch party. Therefore, the anti-hopping provision does not apply to their cases. So, judicial authority, including the Federal Court in Afif bin Bahardin, clearly distinguished between voluntary party defection and expulsion to protect the parliamentary seats of those who are expelled. Therefore, the Speaker declaration of vacancy is constitutionally invalid and Tan Sri Baru and Datuk Seri Buruk remain rightful members of the House of Representatives.
So whether the Speaker's action was constitutional in refusing to declare Datuk Baba's seat vacant, even though he supported a political party after being elected as an independent member. Okay, as for the rules, in Article 49, Clause 1B states that a member of the House of Representatives who was elected as an independent member will lose their seats if they join a political party later. So the seat will immediately become vacant once the Speaker established that there is a casual vacancy. So this provision aims to uphold the integrity of the political representation as well as to prevent the independent MPs from party hopping after being elected. So in the case of Khalid Mehtab bin Muhammad Ishaq and another versus Dewan Undangan Negeri Pulau Pinang and another. So in this case, Afif, who was a state assemblyman, he was expelled from his political party. And then the applicants challenged the Speaker's decision to declare their seats vacant due to a party hopping, which is a state provision that is similar to Article 49A. The Speaker's decision was held to be valid within the constitutional framework because the court reaffirmed that the decision was protected by the parliamentary privilege under Article 72 Clause 1. So the principle established is that as long as the Speaker acts within the constitutional limits, so their actions are immune from the judicial review and their decisions cannot be interfered by the court. So the highlights of this case is that to separate the powers between the judiciary as well as the legislature and to make sure that the parliamentary processes are free from court intervention. So in the case of Ronak Kandi and another versus Datuk Zahir bin Abdul, so the issue is whether the court can interfere with the Speaker's decision on declaring a casual vacancy in Parliament. So the court ruled that courts cannot interfere as long as the Speaker acts within the constitutional limits, particularly on Article 72 Clause 1 and Article 63 Clause 1. So the importance of this case is that it highlights the principle that the judicial body must respect the constitutional privilege and the limits granted to the Speaker, as well as it also strengthens the separation of powers between the judiciary and the legislature. So applying the rules to the scenario at hand, so we can see that Dato' Baba, we have to make a distinction between pledging support to a political party and formally joining into one. So in Article 49A, Clause 1B says that a member who is elected as an independent member will only cease to be a member if they formally join a political party after the election. So we have to differentiate between support and membership. So pledging support is not the same as officially joining the party. So Dato' Baba, he only supports the Prime Minister but did not formally join any political party, so therefore Datuk Baba's seat remains valid and the Speaker's refusal to declare his seat vacant is consistent with the law. So applying this to the Datuk Baba's case, we can see that the Speaker's action by refusing to declare the seat vacant is constitutional, since there is no formal party membership change, and the condition and it did not fulfill the condition under Article 49A Clause 1B. So, and then the court also would likely to consider that the Speaker's decision is valid and it is immune from the judicial interference. Okay, so in conclusion, the Speaker's action was constitutional in refusing to declare Datuk Baba's seat vacant because spreading support is not the same to formally joining it. And it is also established that the Speaker's decision on such matters are protected and by the parliamentary privilege under Article 72, Clause 1 and Article 63, Clause 1 of the Federal Constitution. And the principle here is that as long as the Speaker's action is aligned with the provision, the court cannot interfere, which also reaffirm the principles of the separation of power and also the autonomy of the legislative process.